So thank you to everyone to be here. Welcome to this first month of our Web3 Cardano Bootcamp. I'm very excited to have you all here as we embark on this exciting journey together. So I know some of you know me, but for everyone watching this, my name is Matthias Traussnig. I'm a Swiss qualified lawyer since 2017, and I am currently working at Storm Partners, an important, well-known Web3 consulting firm that is organizing this event hosted by Decentral House, the first Web3 hub in Geneva. So in the past, about me, I have worked in different law firms, more than 2 years at the prosecutor office in Geneva, and almost 2 years as well at Deloitte Legal in Geneva. In addition, I am passionate about crypto. This is the reason why I'm here, and I'm involved in this space since 2016. So some people are watching this in real time, thank you, but please be informed that this presentation is also recorded. If you have any questions, feel free to ask them during this presentation or after. And if it is also possible after this presentation, to contact me directly or someone from the team by email, LinkedIn, or Telegram. You have the choice how to contact us, but we will be free to discuss this presentation or any other topics you want to discuss. So I am currently at Decentral House, and for this presentation, I will share my screen. So I will do it now. Let me know if this works. Wait just 2 seconds. Okay. Here I am sharing my screen. Right. If someone can just confirm that you are seeing my screen, it's working.
Yeah, it works. It works.
Perfect. Thank you, Johan. So today is the second, I will go directly to the second slide. So today is the second episode of this Web3 Bootcamp session. The last one was last Wednesday and can be reviewed as well. I know it has been said in the last presentation, but I think it's better. So we are aligned to mention that. So this month of May, we are dedicating our effort to helping the Web3 entrepreneur acquire the foundational, legal, and regulatory knowledge necessary to establish and maintain a strong business. In my view, understanding the legal and regulatory side of things is crucial for the success and sustainability of any project. This is mentioned here, especially because our industry, so the Web3 industry, is growing really fast. And so this legal mount is structured around 4 comprehensive masterclasses. This one is the second one, to allow you to get the knowledge to understand the most relevant legal issues for Web3 projects, be able to assess the legal setup of your project, understand how works fundraising through token sales and the common contract used in the Web3 space, as well as the risk associated with not complying with applicable laws and regulations. Today, I want really to focus on this last point, so the fact that we need to be careful with some legal risk that can happen really quickly. And it will be the guidelines of this presentation. As you can see here on the right, I mentioned here the program of this presentation. Firstly, I will start with so the first point, why should you be careful in the Web3 space? Then I will present the compliance requirements in financial areas. After, we will go through Web3 specific regulatory issues that can be a bit more specified. Criminal disposition applicable, I think it's quite important. And as I have worked at the prosecutor office, I could maybe give you some tips and really, so you will be aware of potential risks that can happen. Another point will be the personal liability within a business activity. This is not because you create a company that you cannot be personally liable. I don't say that so you are afraid, but it's the truth. So it's important for you to know that, to act according this. And the last point will be a case studies. So the idea is basically to have a case so you can really understand the theoretical point that we have discussed today. About the first point, before jumping to the next page, I want just to stay a bit more longer here to explain you why I decided to have this program. Of course, you can imagine that regulatory and legal risks are a really huge topic. It was not possible for me to mention everything. Otherwise, I think we will stay connected maybe 5 days or even more. So in 1 hour, the point is really to focus on things that personally I think it's important. But of course, you can have other points. The Web3 space is something really special. Of course, this is something fresh, something that allows a certain freedom and allow easy action. As a result, there could be a desire to launch oneself in a reckless way. But on the contrary, I think that is precisely why you need to be careful, because whether we like it or not, so this Web3 space, the law always seeks to apply to regulate the various relationships between humans and companies. So this is the reason why you must be really careful, even if we are in this Web3 space. Moreover, very few people have experience here because we are a young industry, and you can only build reputation by time, and here it's complicated. So to build a reputation. So as a result, it can be very easy to make a mistake, to, I don't know, conclude a partnership with a scam company, or to be just not enough careful when you are doing something. And so you can have some really personal problem, or for your company, you can have problem as well, or even criminal, you can engage a criminal liability. The second point will be the compliance requirement in financial areas. I think, of course, it's really important here. Compliance in financial areas ensure that institutions follow laws and regulation to operate legally and avoid fines, legal penalties, and also reputational damage. All business must take this into account to maintain trust and stability. I mean, in front of the administration, financial stability as well, but also when you are with your consumer basis, it's really important. You must really avoid negative consequences for your business. In particular, the rules on money laundering and QAC duties are very relevant, and I will mention that in this section. Then this is the general principle, but I want to deep dive a bit more on the Web3 regulatory potential issues, because we are here, because we are interested and we are working in this space. The idea is really to identify and discuss issues unique or very relevant, I would say, to the Web3 ecosystem, such as the legal enforceability of smart contract, decentralized governance, and other things. I want to stay in line with the presentation of this topic. So, but as I mentioned before, it will be really complicated for me to say everything. I will have, of course, to decide to select some potential issues you could have, but you will see this in this part. Then I will go directly to the criminal disposition applicable. As I mentioned, I have worked at the prosecutor office, and I saw some criminal disposition applicable to Web3 business, and I think I can give you some input here. Contrary to the initial belief, it's very easy to fall into a general criminal provision as well as a financial one. So you must be really careful. And when I was working at the prosecutor office, it was quite usual that people sometimes didn't know that they have committed a crime. They thought it was just a financial penalty, but at the end, it was not the case. So the best way to avoid that, or anyway, it's a first step, I believe, is to know that you can commit a criminal infraction. Then I will talk about personal liability within a business activity. Of course, this is not because you create a company that you cannot be liable. Understanding your personal liability will ensure you take the necessary steps to shield yourself and your company from legal risks. Indeed, the fact is just because you have set up a company doesn't mean you protect you, as I mentioned. And then the last part before the conclusion, and of course your questions, will be the case study. So I have prepared this case study to highlight potential issues that could arise. This example in two separate sections will provide valuable insight and practical lesson on how to navigate legal challenges effectively. In addition, the benefit will be for you to repeat certain points in summary form and really to understand how fast we can fall into the presentation, the liability and the risk, the legal risk I will mention here. And at the end, my point is I want really to do this case study because at the end of this presentation, my goal is, even if, I don't know, it's just a little voice, I know you are not lawyer in your head, you will maybe sometimes, this little voice will say to you, watch out, be careful, it can be dangerous to do this. I should maybe go to someone to check if it's possible or not. This is my vision, and I think it could be great if you could have at the end of this presentation, this little voice in, I don't know, 2-3 months, if you have a tricky situation and you are not sure what you should do. Okay, so I will go to the next slide. Let's start this presentation. Let's deep dive into it. So here is why should you be careful in the Web3 space. I mentioned, you can see that on the right, many points. The first one is the rapid innovation. As you know, the Web3 space is characterized by technological advancement and innovative business models. While this innovation drives the industry forward and is really nice and we love it, it also means that regulation and legal framework can or often struggle to keep pace. Of course, we saw that in our practice. Sometimes you have rules and we don't know how to apply these rules to this Web3 business. And this can create legal uncertainties and risks that must be carefully managed. For example, blockchain companies are often dependent on opening a bank account. I don't know where you stand in your business, but in our consulting activity, we can really we are aware of the fact that it's difficult for an entrepreneur potentially to open a bank account. And this is for many reasons, but this is because also the industry is not really understood, and you have this QIC, AML, so anti-money laundering problems, and it's the banks are really careful to embark any form of clients working in this industry. Then the second point would be the different legal frameworks. I think that is important. Web3 projects are often operate globally, interacting with users and regulators from various jurisdictions. However, each country has its own legal requirement. This is a legal principle and has also regulatory standards. And this is making it challenging to ensure compliance across all regions of the world. So navigating this different legal framework is crucial to avoid inadvertent violations. Sorry. It is for this reason, for example, that there are sometimes potentially geographical restriction. I don't know if you have participated to some form of IDO, but it's quite usual, for instance, to not accept, I don't know now, Russia or United States or other kind of countries. But I can also point something out. For instance, the procedure for obtaining a license can be different in a country than in another. It's quite, it can happen. And it's the reason why sometimes you have to move your seat from a jurisdiction to another. You don't have to be honest, but it can be advisable. So you can go faster and you can go faster. Then the third point, I think you should be careful in the Web3 space, is the fact that many aspects of the financial and technological landscape are governed by strict formal rules. I already mentioned that. It includes the anti-money laundering, AML, and the QIC, so the know your customer regulations. You have also securities law, data protection requirement, consumer protection, and it is really important adhering to these rules to maintain the legality and integrity of your operations. In a nutshell, this means that you are either inside our or outside the framework. I mean, this is not great. Sometimes if you do the QIC or you don't do it. If you didn't do the QIC, it's complicated then to go to the bank and say, yes, we have done it. So you must be careful with this. And this is the reason why I think this is strict formal rules and they need to be followed. Then we will go through we have the potentially heavy penalties that can happen. It is not because we are in the Web3 space that there is not penalties. In the opposite, the penalty can be quite important. In some cases, you can have criminal charge, as mentioned before. So again, you must be really careful with this. Another point is ensuring trust. I think you should be careful in the Web3 space because trust is something that is complicated to acquire. User is really important in our space. It's normal to, for instance, to launch a token and to really have a community. And if they don't have trust, it's complicated. And of course, when you have some problem in the media, for instance, I don't know, you can a media says that you are not compliant, you don't do the QIC process, you have no TNCs and these kind of things. Of course, you can lose the trust of your community. And another point is if you have a condemnation, a criminal condemnation, I mean, of course, it's not good at all and for your community as well. Then the last point I think you should be careful is preventing business model downfall. Indeed, legal misstep can lead to several disruptions in your business operation, from costly litigation to forced shutdowns. You must be aware that this can happen. This is not just a small fine and you pay it and you are done. It can be, but it can be way more dangerous for your business. As mentioned before, you can also have a criminal liability, and this is something that is not good at all for your business. I mentioned at the beginning of this point that high stakes issues are on the table. I think this is really the case, and this is the reason why you must be careful, and you can fall really rapidly. So an example that all of you know, and I'm quite sure, is the FTX platform example. In 2 weeks or even less, we had a really growing business and the platform was shut down, and now we have a liquidation process, we have a penalty, we have criminal sanctions as well, financial sanction, of course. So it can be really fast, even if you are a strong player in this in the ecosystem. I will go to the next slide to discuss more specifically the compliance requirement in the financial area. For me, here I want that we have a closer look at 3 different points. So the first one is the anti-money laundering, AML point, the consumer protection law, that is important. And I want also to discuss the data privacy, the potential data privacy issues and regulation that you need to meet. As mentioned before, please note that this is not exhaustive. I really decided to talk about it today, but you can have many compliance requirements, and that's not it. If you meet this, I would say you are in the good way. You are on the path, but it's good. But then you need to assess a business. Each business is different. It depends on your activity, and depending on your activity, you will have to comply with the other legal requirements. So let's start with the first one, the anti-money laundering obligations you have. So the AML regulation are designed to prevent the use of financial system for money laundering and terrorist financing. So it's quite important. These laws require business to implement processes that detect and report suspicious activities. We are talking about money, as you understood. And of course, if you have a business, you have some financial transaction, and you need to be careful with this transaction potentially. The requirements are the following. So the first one is the know your customer process. Businesses must verify, and I say must verify their customers in identities and assess the risk associated with each customer. This includes collecting and verifying information such as name, address, and other identification documents. This is really important. Of course, more the amount invested by a customer is important. If, for instance, you are selling, I don't know, token with SAFT, so with a kind of agreement, you must be careful. If someone is telling you that he will invest, I don't know, 1 million into your business, this is a point that is really crucial. You need really to check who is this person, where this money comes from. And when I say you, it's not necessarily you. You must ask to a professional. So normally it's a third party professional to do it. It's the best way, in my point of view, to handle this. The second point that is really important is the transaction monitoring. You need to monitor your transactions. So I mentioned investor before, a customer, but you can also have, I don't know, a payment from a subcontractor, or I don't know. You must be careful with this kind of transaction as well. And then the third point I want to mention here is the fact that you have some suspicious activity report. This is the obligation to report any suspicious transaction or activity to relevant authority. You have this obligation in many jurisdictions, not in all jurisdictions, but of course, what you should do if you have suspicion, it's not to accept the money, basically. This is the point. You have this report suspicion. I will mention that when I will be in the criminal part when you are a professional. So it depends your status, depends your jurisdiction, but basically you must be really careful if after the QYC you have some huge doubts. You must be careful. Yes, because non-compliance with AML regulation can lead to severe penalties, including fines, sanction, and reputational damage. It's really, in my point of view, essential to have a robust AML policies in place so you know how to deal, your employees know how to work with this, how they must act if they have suspicion, for instance. And so you will be backed, and even if there is a problem, if the regulatory body can see that you have a process in place, it's very important. To have a pragmatic vision, the key administrative legal measure for entrepreneur in the crypto space, in my point of view, are so the customer due diligence, I mentioned that, the transaction monitoring, to really stop the work if you are not sure about the origin of the money, the record keeping, so you cannot just discuss everything. I think it's really important to have a record keeping, to have a clear guidelines in your company, potentially to train your employee, or I don't know, to ask each employee is dealing with this to check the policy in place, for instance. When you are not sure, maybe make a risk assessment in writing. It can be important. And to have internal control can be a good option as well. Of course, normally, huge company do this internal control. Before joining Storm Partners, I worked at Deloitte. I know we had some internal control, but of course, this is a big company, one of the biggest company in the consulting activity. So this is the reason why they did that, but sometimes it's not possible. But if you are growing, it can be an option for you to have some internal control. Of course, please note this measure must be done in advance. As mentioned, you can understand, I think you cannot draft your guideline after when something bad is happening, when the regulatory come to you, for instance, because there is a problem with some funds that you have accepted, because I don't know, the client has been is in a criminal procedure, for instance. So let's be careful. I like the idea that you cannot construct a boat when you are sailing in a storm. This is a bit this. You must do this in advance. And when we are working here at Storm partners, we always advise people to put this in advance. Of course, this is an investment, but this is something that this is better to do it in advance. Sometimes it's too late to do it after. And even if we can still do it, it costs more money than if you have done this at the beginning. As mentioned, I already mentioned this before, but the banking relationships is something quite interesting. Indeed, banks are heavily regulatory entity that must comply as well with the AML policy. For your Web3 business, to open a bank account can be complicated. And so this includes showing that you have effective KYC procedure, transaction monitoring system, and reporting mechanism in place. Banks are already suspicious. So if you don't have this, this will be quite impossible or very complicated to open your bank account. AML compliance is crucial for building and maintaining trust with bank. And to just open the bank account. So this is the first point I wanted to mention to you. Now I can go directly to the second point, the consumer protection law. You might be surprised to see this here. I think it's really important because the consumer protection law are designed to safeguard the interests of consumers, ensuring they are treated fairly and protected from potential unfair practice. So it's very important that you follow some requirements. You must follow the transparency principle. This means that you have to be clear and honest in your communication. You cannot, for instance, I don't know, mislead the potential consumer. This is not admissible in a lot of jurisdictions. And finally, you must be very careful because if you do that, this consumer has the right to go in front of the court and just pursue you. So you must be careful with this. This is something I wanted to mention. So when you sell a product, you must be honest. You must explain what you are doing and not, I don't know, not saying that you are selling something that you are not doing. It can be. Of course, you can always in the practice be in the gray zone, but it's not so advisable because it can be really dangerous. And if you, you mislead the potential consumer, you can have some problem, from a private law point of view, but also from you can have a problem from a criminal point of view. And I will mention that after in this presentation. Then the last point I wanted to mention here is the data privacy. A data privacy law governs how business collects, store, and process personal data. These laws are designed to protect individuals' privacy and ensure their data is handled securely. Key requirements include first, the user consent. This means obtaining explicit consent from user before collecting and processing their personal data. Then you have the data security. This involves implementing robust security measures to protect. So this is the protection of the data. And finally, you have to respect the rights of individuals. This requires respecting individuals' rights regarding their personal data, including the right to access, correct, delete, to not use in a certain way this data. This is some points that are really important. And you may know, for instance, the General Data Protection Regulation, the GDPR in Europe, and you have another law here in Switzerland that is quite similar. And this law is really strict. And now if you don't follow it, you can have sanctions as well. So you must be really careful because in a lot of business, you will have data. I mean, I talked at the beginning about money, the anti-money laundering point. You will have funds because it's your business needs to live, but you will also have data in almost all the business. And it's really important in advance to know how you will deal with this data. I will go directly to the next slide. I see that the time is flying. So here is we come really to the core of this presentation, the specific points to be considered in the Web3 space. So I mentioned 4 different points: the client onboarding procedure, the funds injected by investors, network decentralization and data treatment. I mentioned that just in the last slide, and the standard legal framework applicable to the Web3. So I mentioned the AML obligation. This is close to this. As discussed in the previous slide, robust anti-money laundering is absolutely necessary. In the Web3 space, client onboarding involves verifying the identities, I believe, of users. And you can have a lot of users. I mean, when you, for instance, you are doing, I don't know, an IDO. This is also the second point of this presentation, but I can do it together. When you are doing an IDO, you will have a lot of people coming to you, and you have to collect potential data. And when you collect this data, it's important to use this data adequately and to mention to people that you are collecting this data. This is very important, I think. About the QIC, just to say something about this, I think it's important because the QIC not only helps in complying with AML regulation, but also build trust with banking partners and regulatory authorities. So you need really to do it. Fine, to come to the next point, the funds injected by investor when raising funds through mechanisms like initial decks. It's crucial to have a really clear procedure. To mention from my perspective, a project that has no QIC, clear QIC process or no QIC at all, that has no TNC drafted, no privacy policy, I'm really suspicious. This may be because of regulatory problems that will become, it's a possibility, but also I think if you are a team and you are building something and you care about your community, it's important to regulate what will be your relation and to do things in a compliant way. Before, I don't know, 2020, for instance, it was more complicated to do things correctly. It was possible, but no complicated. But now we have a legal framework. You have some legal specialists that can assist you a lot. So this is not an excuse to say I am the Web3. This is the reason why I didn't comply with the QIC process. No, you have this obligation and you must handle it. This is really important. Then to go to the third point, the network decentralization and data control. Decentralization, in a point of view, can pose a unique challenge for data control and privacy. Indeed, in decentralized network, data might be distributed across multiple nodes. And secondly, information on customers, might be transmitted. This can be a problem for you. So to address this challenge, it is crucial to implement comprehensive cookie and privacy policies. These policies should clearly outline how data is collected, stored, and processed across by the project, I mean. You have 2 kinds of essential policies that you must have on your website to regulate the relation that you have with your customer. The first one is the cookie policy. This policy informs users about the use of cookies on the platform. To be clear, cookies are the small data files stored on user devices that track and store information about their online activity. So you can do this activity, but you must have a cookie policy. It's again about informing the person that you are doing this, and this person needs to accept it. And then you have a second policy that is important, is the privacy policy. This policy explains how personal data is handled within the decentralized network. It should cover the following key aspects, in my point of view. So the first one is the data collection. I mean what data is collected and how you are collecting this data. Then the data use, what data is, how the data is used, what kind of data is used. Then the data sharing. You can have a subcontractor and you can share this data. You must mention that. The data security, where is, I don't know if you have a cloud, for instance, where is stop your cloud, what are you doing with this data? It's again about what you are doing, but the security, because if you have a subcontractor, you are using someone, you cannot just say, I have sent the data to this person, I don't know what this person is doing with your data. You must be way more specific. And finally, I mentioned that in the previous part, is the user rights. You must explain to the user how we can exercise the right to correct, to delete the data, and how we can manage the treatment of the data. A few months ago, it was more complicated to send data to United States. So now it's way more easier. There is a shield, an agreement between different countries. But be aware that sometimes sending data to a country outside Switzerland and Europe can be really complicated from a regulatory point of view. It's the case for Asian countries or African countries. Then to go to the last point of this slide, the standard legal framework applicable to Web3. As introduced before, this is an important topic in my point of view because Web3 operates across multiple jurisdictions. It's quite one of the fundamental pillars of our industry that we are international, I would say. And this can create friction, especially with compliance requirement, because the law change from country to country, and you must be aware of that. This is the reason why you can put some geographical restriction, or just you can in a country could have a really permissive QIC procedure. Another one can be more strict. So this is the reason why I think when you are doing the QIC process, you need a strict approach. And it's not so complicated if you have the good third party to assist you, but you need to do this check. So to conclude here, I think I told you everything I wanted on this slide, but to summarize all I said, it's really important to have a robust AML procedure that comply with all the country you are working. You have some consumer, I would say. You must have clear investor terms and effective data control, and you must inform your client that what you are doing. It's really two very important points. Then let's go to the next slide related to the criminal law. So here is a list of potential problematic. You have the AML violations, the cyber crimes, the fraud and financial crimes, the tax evasion point as well. As you imagine, I am quite sure having a criminal procedure goes way beyond an administrative or civil sanction because it can concern your business or it can concern yourself. And trust me, I've assisted some person in this kind of procedure. It's not the nicest thing to have. So I will mention that in related to the AML procedure. About the cybercrime, so you have cybercrimes involve illegal activities conducted through digital means, including hacking, data breaches, and the spread of malware, for instance. The decentralized nature of Web3 platform make this possible. You can have preventive measure, and it's quite advisable to do it. And I want to mention this for two aspects. So the first one is you can commit a cybercrime, even if you are quite not, you don't want to do it, but for instance, you partnership with a company and this company is a scam, or the platform you want to sell your IDO, you didn't do the check. Honestly, you can be in the procedure and have some problems. So even if, of course, it's not your business model and you don't want at all to commit cybercrimes, it can go fast. So you must be careful with the people you are contracting partnership with. And the other point is you must protect your platform from cybercrimes to happen. And this is really important because the trust and the safety of your users, I think, is really important. So strong cybersecurity measure help prevent you from that. Then the third point is the fraud and financial crimes. So fraud and financial crimes include a range of illegal activity. You can have the Ponzi pyramidal system, the investment scam, the misrepresentation of financial information. So you can have really a lot of different form of potential fraud. This can go when you do a fake ICO, if your tokenomics is not right. You must be diligent. This is my advice here to avoid this. You must be diligent and you must prove that you have been diligent. I mentioned before in another slide, in the compliance requirement in financial area slide, that you must be diligent and you must put in writing what you do. And you must have process in writing. I think this is exactly the same here. If there is a problem, you have to go in front of a judge, a prosecutor, or I don't know, and you can explain why you did that, why you decided to go with this subcontractor. Even if there is a problem, if you can explain, this is a really good point. But then in the next slide, I will explain you how the criminal system is working in Switzerland and in other jurisdictions because it's quite the same. Then the last point is the tax evasion. This is a big topic, of course. So I am not a tax lawyer, so I could not go deeply into this, but this is a potential risk for entrepreneurs, and I think this is important to mention it and you are aware of it. So to give you some general guidelines, in a nutshell, as you may know, tax evasion involves the illegal no payment or the underpayment of taxes. In the Web3 space, tax evasion can occur for unreported income, for instance, from digital assets, or failure to pay, I don't know, capital gains taxes. To avoid this, you have to accurately reporting what you, so strictly reporting, you have strictly reporting obligation requirements. Indeed, reporting income from digital assets is essential. You must be transparent, I mean. And this is important. Another point, if you have a company, you must ensure compliance with tax laws in multiple jurisdictions, especially if your business operates globally. So maybe the tax obligation, and this is the case, for instance, the tax obligation in France is not the same than the tax obligation in Switzerland. And you must be careful and you must deal with that. So this is the reason why this can be complicated, even if your seat is in a country, because if you have a company, the company can be in Switzerland, but I don't know, you can hire someone and this person is only working this place. So from a tax point of view, it's like you have a stable establishment somewhere and you will have this establishment will have some obligation. So yes, normally you have the obligation in the country you have your headquarters, but it can be way more complicated, and this is the reason why it can be advisable to consult a tax specialist when it's about this problematic. To go to the next slide, so the crime related to the criminal law. As you can see here, I have mentioned an article, a relevant article, but before reading it, I think it will be better to explain you how the system works. So in short, we need someone to be to do an interaction. We need a typicity of the repreached behavior. The typicity refers to the specific characteristics that define a behavior as an infraction under Swiss law. In general, you have 4 conditions, and these 4 conditions must be met to be guilty. The first one is a guilty act. The second one is a guilty mind. And then you have the causation. So you need a link between your act and what happened and harm. So you need someone that the harm has received something. I mean, the harm has caused something to someone. This is the basis of the Swiss system. And here to jump to this article, you can see this article is related to the money laundering potential problem. This article target action that obstruct the identification and tracing of assets known or suspected to come from a third party. This means, to be clear, any person hiding the identification or tracing of some assets can face up 3 years in prison or a monetary penalty. All the article mentioned prisons. You won't go in the prison the first time you do something, or you can go in the prison if it's really a huge, something really huge you did. But the principle is at the beginning, you have a monetary penalty. So don't be too afraid when I say 3 years prisons, but if you do that many times, I don't know, 1, 2, and then you continue doing things in bad way, yes, you could, it's a possibility. In Geneva, for instance, in the prosecutor office, when the prosecutor is working, it happened. Then to go to the next slide, I'm just doing a little bit. I'll let you read this slide. So this slide is related to the insufficient diligence in financial transaction and right to report. This article addresses the responsibilities of professionals who accept, hold, or assist in managing external assets, highlighting the importance, again, of identifying the beneficial owner and the funds. Any professional who fails to identify the beneficial owner of the assets with due care faces a custodial sentence of up to 1 year or a monetary penalty. So here we are really talking about the right to report. When you have a suspicion, you must report if you are a professional. What is important here in this article, and this is the difference with the other article I mentioned before, this concern professional, but this will apply to banks, for instance. And here, and I think it's the link with the compliance requirement I mentioned before, a bank accept you as client and you don't do your due diligence and they transfer funds and they say nothing, the bank can be liable. And this is the reason why a bank is suspicious with a new industry. And it was the case at the crypto industry at the beginning. Now it's possible to open bank accounts, but it's still complicated with a lot of banks. You must find some bank that trusts you and you must show that you are doing things in the right way. But yes, this is to mention to you that bank can fall into this, and this is the reason why they have a really conservative approach. And it's really important that your business is well managed. Then I will go to another article. I won't stay too long on this article, but I think it was important to mention it. This is a very broad article, but often applicable. I think in my career, this is the article I saw the most applicable. So I let you read it. This article concerns fraud. To summarize this, when you are reading it, fraud involves including another person into a wrong belief through false affirmation or by concealing the truth. As you can understand, this can go really fast because the simple fact of concealing the truth can fall into this. As mentioned before, you must have the intention to do it, but it can go really fast. And if you have a business, for instance, and you don't explain what you are exactly doing, you want just to raise money, and someone could come, and you are based in Switzerland, or the client is based in Switzerland, so you have a link with Switzerland. Someone could go to the prosecutor office and say, I want to confront this person, and I think he committed this infraction. You have three relevant elements here. So the unlawful gain, the inducing wrong belief, and the resulting harm. Then I will go to the next point. This is a point related to the criminal mismanagement, sorry. But related to the management. But yes, this article highlights the responsibility of individuals who are entrusted with managing someone else's property. This can be someone acting as a board member, for instance. It shows, in my point of view, the importance of adhering to legal and fiduciary duties, as well as regulatory requirements to protect the property owner's financial interests. The owner can be the shareholder or the creditors, for instance. So really, when you have a business and you think that you have created an entity, so you are fine, you must take careful, and you have some obligation and some diligence obligation. You must be careful, and you cannot mismanage the funds of someone else. Okay, I will go to the next slide related to personal liability. This is the last topic, I believe, before the case study. So as you have seen just now, Swiss law imposes penalties for violations such as fraud, mismanagement, and money laundering. These laws are designed to protect financial interest and maintain the integrity of the system. I think you understood how it works and some attitude that we cannot accept. But in addition to criminal implication, you can have some corporate liability. This includes personal liability for management, which means that individuals in leadership position can be held personally accountable for the actions and decisions made within their corporate roles. You must be aware of that. And I mentioned just here, so here it's a general article in the Swiss Code of Obligation that mention some of the obligation that a board of director has and cannot delegate. You can have, of course, an other obligation, but here you have some important obligation that are really on you. And to link that to the next article, so I will go directly to the next slide. You can see for these duties and other ones you have, board member can be held personally liable. If you read this article, of course, you can have access then to this presentation. You will see that, yes, you have this responsibility. And it's a personal responsibility. It means, for instance, I don't know, you were a big company and the shareholders lost, I don't know, 2 million because you acted badly. The person could come after you and you could have to pay on your personal assets, these 2 million it can be. And in some cases, you could have the fact that you will have, I don't know, to sell your house or to sell a lot of important assets for you. So it's something that need to be noted from your side, and you need to be aware of that. Okay. Now let's jump on the case study that I have prepared. I let you maybe 1 minute to read this first part, then I will go to the second part and we can discuss everything. Sorry. Okay, the case study is quite short, so I go now to the second part. So I think that you had the time to read it. I can so go to the answers. In my point of view here, in this case study, you have some problems and huge problems. The first one is the fact to accept 5 million, a 5 million investment without proper due diligence, especially under rush circumstances. You are it's a violation of the anti-money laundering regulations. And of course, you cannot launch an IDO without clear terms and conditions. Further, this is a breach of, and you engage your liability. And the consequence of this is the fact that the regulatory bodies may impose you heavy fines for this violation, and you could have also criminal problems. This is what I mentioned. This is the first point I mentioned. The second one is legal actions. As you mentioned, as you know, it's not only the regulatory body that could come after you. Person could also ask you answers, and they could pursue you. So you could face legal actions because we studied before the consumer law, and you have other potential law in the code of obligations, and you didn't respect that because it was not clear what you were selling and the price and this kind of thing. That must really be clear. It's really important. Then you could have a criminal problem. We studies, we spend a bit of time on the AML obligation that you have. And here, if you just accept money without QYC, because the other parties in a rush, it can be, you can have some criminal charges. And then the last point, I wanted to mention that because we are talking about law, but it's important to have also to have an overview on what we are doing, and you can also have a reputational damage. I mentioned that in the introduction, but it's really important to insist this. If a legal action is open against your business or yourself, of course, you will have reputational damage as well. This cannot go good for your business, even if at the end you can demonstrate that you did the things right and you win your case. You have this reputational damage because people will judge you, and as you may know, legal procedures are quite slow. It takes time, and during this time you can lose, I don't know, for instance, potential client, consumer will quit your platform to go to a competitor's platform. So it can be really dangerous for you. So I will go directly now to the conclusion, and this is something that is really important and it guides you during this presentation. It's good to respect the compliance obligation you have, but what is more important is to do that in advance, I think, because it's very, and I mentioned that in the last sentence of this presentation, prevention is much better than cure, and I really strongly saw that in the practice, and it's something you must really have in your mind. Sometimes it's too late. It's just too late. You made a mistake, or it will cost a lot of money to resolve the problem. But if you do the things in advance, sure, this is an investment, but at the end, it's a valuable investment for your business growing and for your users as well. Okay, so here is what we are doing at Storm Partners. So as I mentioned at the beginning, we are a consulting firm. We are providing a lot of advice in the legal area, but we have also other departments. We are involved for a few years in this industry now, and we assisted a lot of clients, and we can basically do, I think, a lot of legal problematic that you can do in the Web3 area. It can be related to Switzerland, but it can be also outside Switzerland. We can set up company in offshore jurisdiction and do other things. So we are mainly specialized in all the legal issues you may have. Here you can see this is our team. So you have Nicolas Masella, the person who did the presentation last week. He's the head of our department. Myself, Matthias Traussnig, legal manager. Rocco Impecora, legal manager as well, and Justin as well. So I think that's it. Let me know if you have questions, comments. It will be a pleasure to answer them. So let me know.
Hi, Matthias. I have a question.
Of course, teacher. Let me know.
I always have a question. If you are on the board of directors, obviously you're one among several people, and maybe you don't have the capability to completely drive the company to do the right things, especially on the day-to-day, right? So what can you do to protect yourself, either as a group of directors or as an individual, from either something that you were personally ignorant of, even if the board knew, or the misbehavior of people under you?
It's a very good point, DJ. Thank you for the questions. It can happen, of course. It can happen really fast. You cannot be specialized in everything. Not everyone is a lawyer. As I mentioned, it's important to put everything in writing. So if I was not a lawyer and I spotted something and I know I don't have the capabilities to do what is right, I will send to all the board members an email or something to explain. So in writing, it's really important to explain what I spotted and that we need to solve that. It can be, for instance, to hire a specialist. I don't know, you can mention that. And it's always possible to say that in an email, that you don't have the capabilities and you think that the board has not the capabilities. And if this is the case, someone can say it. But if you don't have these capabilities, we should use, I don't know, allow a budget to hire someone to solve this problem. For instance, a law firm or a legal advisor. This can be a possibility. And so to answer your question, DJ, you will be safe from a criminal or a civil point of view. I don't know if someone else has a question or any comment. If yes, this is the moment. Do not hesitate. Otherwise, as mentioned, you can contact me. Or contact Storm Partners. We will be really pleased to assist you if you have an issue, a legal issue, or another issue. It will be a pleasure. Because yes, I mentioned this rapidly, but Storm Partner is also providing advice on a marketing perspective and on a fundraising strategic perspective. So the point is we can really assist you. We can assist your project on many different aspects. If no one has other question, I will conclude. and I will close this. So I want just to thank you. Thank you to have listening this presentation, and for people that are showing this, they are watching this, you are free to contact me as well. Thank you. Bye.
Bye.
Thank you, Matthias. Bye.
Thank you.